Thank you so much for joining. I'm Samar Shams. I'm managing partner at Changes Immigration. There we go. So Changes Immigration is a immigration law firm. We're based in the UK, and we handle UK inbound business immigration matters. We handle global mobility projects for multinationals, and we also handle UK inbound personal immigration matters. I'd like to introduce you to my colleague Medea as well. Medea, would you like to say hello?
So, hi everyone. Thank you so much for joining. My name is Matia Krasaiva, and I am an associate at Changes Immigration.
Thanks. Okay, so just some housekeeping. You'll notice that chat is disabled. Please put any questions in the Q&As. Your name will be visible when you submit a Q&A, just so you know, and this session is being recorded. Now, if you are an immigration advisor, UK immigration advisor, please don't ask us questions about your cases. I do present training for immigration practitioners through the Immigration Law Practitioners Association. All of their training is great, and I would encourage you to look at their website if you are an immigration practitioner looking for that kind of support. Also, those of you who have joined us for webinars before will know that I love an interactive session. We maybe were a bit over-eager in terms of how excited we were about the content today, so we've really packed this session in. It's possible we won't get a chance to answer all your questions. So please do contact us if we don't get to your questions today. Note that this is not legal advice, okay? So again, get in touch if you'd like advice. This is just information. We're going to be presenting kind of overview level of information, but if you have specific circumstances you need help with, please do get in touch. We have a whole suite of services to help with immigration compliance. All right, without further ado, Nikki, if you could start off the slides for us. Welcome to the Sponsor Compliance and Right to Work webinar presented by Changes Immigration. Next slide, please. I'll just run through the agenda quickly. So first, we're going to go over some points relating to right to work, defining illegal working, going over the transition that's ongoing to e-visas and away from physical documentation, a quick run through the significance for no time limit applications, and then we'll go over the basics of right to work check processes and keeping evidence of those. Next slide, please. The second section we're going to present is on sponsor compliance. So we'll cover compliance duties, record-keeping duties, and reporting duties, which are the main sponsor duties. And we'll review risks of non-compliance and what to expect during different types of compliance checks, including compliance visits. Next slide, please. Now, this is where we got maybe a bit overeager, but we're really excited to share some tips and updates. So we'll be talking about some changes to key personnel requirements for sponsors, changes to certificate of sponsorship processes of which you should be aware, a tip relating to sponsoring people as new entrants, and changes for sponsorpreneurs or self-sponsored skilled workers, and also just a very quick run through the employment law requirements that sponsors are responsible for. Next slide, please. So let's get right into it. Right to work. Next slide, please. What is illegal working? Well, most people would answer, well, it's working without work authorization. But actually, what's really common is that people have some form of work authorization, but they're not authorized to do the work in question. And this is where employers get tripped up unintentionally and are unintentionally sponsoring or employing people who don't have the appropriate authorization to work. So it might be a matter of limitations on the worker's hours. For example, students are allowed to work depending on their the degree course they're following, but there are restrictions on the hours they're allowed to work. And so sometimes the illegal working consists of surpassing, exceeding those restrictions in the type of work, in the hours you're doing, or in the role you're doing. And what's really common for sponsors is that they sponsor somebody for one role, the role changes, that's not reported to the Home Office. And so that is actually technically illegal working. It happens a lot more than one would think. Next slide, please. Now, you will have seen in the news that the Home Office is coming down hard on employers who are employing people without the appropriate work authorization. There's an unprecedented level of fines being levied against employers. The fines are now up to £60,000 per illegal worker and or instance of illegal working. And there are also criminal powers that the Home Office can use to enforce prevention of illegal working. So it's very rare that these would be employed, but ultimately there is the possibility of up to 5 years in jail and an unlimited fine. What the Home Office has used historically is a power to close down business premises. They're able to close down business premises. So the compliance officers are able to close down business premises for a short period of time, within which they go to the judge, and the judge can shut down a business's premises for up to a year, or they can issue compliance orders, so requiring the employer to undertake checks at certain times in addition to what's required, as standard. Now, being shut down for a year is really would really be the death knell for most businesses. So it is very important to ensure that you're not employing anybody who's not authorized to do the work in question or doesn't have any work authorization. Other consequences of illegal working would be revocation of a sponsor license if you have one, or if you don't have one, you might be ineligible to apply for one, at least for a certain time. Finally, the Home Office publishes the names of employers who are found to have been liable for illegal working fines. Next slide, please. All right, so how do we avoid these penalties? Well, you have to check people's right to work according to Home Office guidance. If you do that, you will have a statutory excuse against civil penalties and also a reduced risk of criminal penalties. Now, there are 3 different ways of checking people's right to work. There's an online checking process involving share code. There is manual checking of certain documents for which the Home Office publishes lists, or you can use what's called an identity service provider, or IDSP. We'll go over each of those in a bit more detail. Next slide, please. But basic requirements that are relevant across the board, regardless of the method you're using to check right to work documents, are that you check the right to work of all employees before they start employment. Otherwise, you won't benefit from this statutory excuse to the fines, okay? I'm just going to repeat that because it's very important. Check people's right to work before they start working, okay? Now, for some employees, those who present temporary permission to work in the UK, you have to recheck their documents, okay? And that will depend a bit on what you're presented with. We'll look at that in a minute. But again, basic requirements across the board are that you're checking for 3 main things: that the worker is authorized to do the work in question, so that includes, hours restrictions that we touched on, and the role. Ensure that the expiry dates of their permission haven't passed, and that the photo or image of the person that's on the right to work documentation, that's consistent with their appearance. and also that their date of birth is consistent with their appearance. That can get hairy. We're not going to go into it now, but that's the basics of what you're looking for. Right, Mattia, would you like to discuss the transition to e-visas? I'm sure that's a topic that everybody's very interested to learn more about.
Sure. Nikki, if I could have the next slide, please. Yes, so e-visa transition is probably one of the most significant developments in the right to work checks procedure. So as part of the larger government plan to digitalize immigration systems, the Home Office phased out all biometric residence permits and biometric residence cards. So they are no longer being issued, and those who have the cards would note that they expired on the 31st of December 2024. So instead of the BRPs and BRCs, we now have e-visas, which are essentially electronic records of immigration status. And all visa holders can access their e-visas using their UK visas and immigration accounts. So e-visas are now used to prove right to reside in the UK, right to work, and right to rent. And those individuals who have retained their BRPs or BRCs can use them to create and access their UK VA accounts and access their e-visas. Next slide, please, Nikki. Samar, would you like to touch up on the no time limit applications?
Sure. So just a quick note on this type of application. So this is relevant for people who have indefinite leave to remain or indefinite leave to enter the UK stamped into a passport, okay? If you have that permission in an expired passport, then you're not going to be able to present to an employer right to work documentation in line with the Home Office guidance. Flip side, if you're an employer, you're checking somebody's right to work and they present you with indefinite leave to enter or remain in an expired passport, you can't accept that. So what this individual has to do is basically apply for an e-visa using their expired passports. Now, the Home Office has recently changed the cost and basically abolished the fee for this route. And so it's really important that people do apply for e-visas if they have their indefinite leave to remain in expired passports. It's called a no time limit application. Just note that those with right of abode, that's kind of a separate kettle of fish. And so they're not eligible. If you have questions about that, those applications, get in touch. I think we had a question in the Q&A about more freedom of movement and reduced salary requirements. Certainly there are rumors about that, particularly the potential to open up the youth mobility scheme to EEA nationals. That would be great. And the UK's immigration fees are relatively high compared to other countries, really quite high. And so, we can only hope that they will take that into account and reduce the fees. But I have spent much of my life speculating about what the Home Office will do, and I don't recommend it. So just wait for the official announcements is what I would say, but fingers crossed. Right. If we could have the next slide, please. Okay, so we've discussed the basics about right to work checking, regardless of the method that you're using. Let's talk a bit about each of those methods. So there is the online method using a share code. That is not going to be available to everyone. You can check, you can use this method by video conference, but you do have to be in the person's presence, either by video conference or in their physical presence. So online checks, that's one way. The second way you can check documents is to conduct manual checks. Again, there are specific documents against which you can do these types of checks. Or you can use an identity service provider that's only for British and Irish nationals with current passports, or for Irish nationals, current passport cards. Okay, Medea, do you want to tell people a bit more about the online checks using share codes?
Sure, Nikki, if I could have the next slide, please. So as mentioned, online check right to work procedure is the check that is essentially based on share codes. So those individuals who have BRPs or BRCs, their right to work can now be checked by accessing the e-visas. EEA nationals and some family members of EEA nationals who have statuses under the EU settlement scheme, they will be able to provide a share code for the right to work check, and also frontier worker permit holders. You can tell who might have access to the e-visas by, if you have this details, of course, asking if they used a BRP card and the Home Office's app in their last application, or if it's an EEA national who has been residing in the UK for quite some time, it is likely that they might have access to e-visas if they have a status under the EU settlement scheme. And also the holders of British national overseas visas, those you would normally expect to also have access to e-visa. Next slide, please, Nikki. So this is a general overview of how you conduct the right to work check based on a share code. So first you need to obtain permission from the individual. They would need to provide you with a share code, and this is how they can generate it by entering the details on the Government UK website. They will be provided with a share code, and that share code you can then use to check right to work on your side using their date of birth. To note, share codes are only valid for 90 days, and the specific share codes for the purposes of right to work check would start from letter W. Next slide, please. Yeah, so we've already covered that. And once you access the individual's right to work check profile, it is very important that you verify that the individual that you are employing is in fact the individual on the right to work check profile. So you can verify this by either meeting the person in person or by video link. But it is very important that you do either of this for the compliance purposes. And if you do obtain a positive online check, you will note the end date of the individual's permission to reside in the UK, which would either be an expiry date or a note that they can remain and work in the UK indefinitely. And obviously see the person's photograph. And what you would need is to note the date that you conducted the right to work check. Next slide, please, Nikki. Yes,
Great.
manual checks. I
Let's
will
talk
hand
about.
over to Samar.
Sure. Thanks, Medea. So manual checks. Again, documents have to be checked in the presence of the holder. That means that the person checking the documents has to have the original hard copy documents in their hands. You can then either be in the physical presence of the person or be checking via video link, but you have to have the original documents in your hands. So for example, a new employee before they start work would enter the UK, post their original passport to you if they're not going to meet with you in person. And then you would check their right to work during a video call whilst holding their original passport. We had a question in the chat. Please do put your questions in the Q&A functionality. We had a question come through in the chat as to whether you have to use an IDSP, so identity service provider, when checking British nationals. You don't have to, but that functionality allows for you not to have the original hard copy documents in your hands, and that's why that functionality, that option exists. You can check British and Irish passport holders, but you have to have the original hard copy documents in your hands to do so. Okay, next slide, please, Nikki. So one thing you're looking at when you're conducting manual checks is whether the document is genuine. People often ask me, oh, well, how do I know if it's genuine? The standard to which you're held is just the standard of someone who's not trained in identifying false documents, but you are expected to examine it carefully. You're not expected to use technological aids to examine it. And if you do that, you should reasonably be expected to realize that the document in question is not genuine. So you're looking for things like, peeling, lamination over the photograph, maybe something looks like it's been written over, things like that. It's not, it's not a very high technical standard to which you're being held. So as long as you do the check and you're reasonably live to issues with the documentation, but you follow the government's processes, then you should benefit from the statutory excuse from civil penalty. One thing to note is that if somebody presents a combination of documents with different names on, then you should ask for additional documentation to explain the name discrepancy. So maybe a marriage certificate or a deed poll relating to the name change. Next slide, please, Nikki. So I mentioned that if you're doing manual checks, there are specific documents that are listed in, that are published by the Home Office, and they fall under different lists. Now, what you have to do when you're conducting a manual check will depend on which of these lists the documentation that you're presented with falls under, okay? So there's list A, that's documentation that evidences an indefinite right to live and work in the UK. And if you check that before the before the individual starts work, then you will benefit from a statutory excuse for the duration of their employment. List B documents are those that you might be presented with that reflect a temporary right to work in the UK. And those documents break down into two groups. So one allows for a statutory excuse until the date of expiry. With the other group, group 2, you have to take an additional step of obtaining a positive verification notice from the employer checking service. And I just want to take a moment to clarify that this is a different process than the online process of checking right to work using a share code. They're both online processes, but the employer checking service positive verification notice process is different to the online checking process using a share code, okay? And it's for group 2 documents. Those documents allow for a statutory excuse for the 6-month validity of the positive verification notice. So if you're granted a positive verification notice, it will be valid for 6 months, and you benefit from the statutory excuse during that 6-month period. Next slide, please. You would then have to conduct a further check. Now, I'm not going to read through all of these documents, don't worry, but I thought it would be worth just showing you the lists and highlighting a few things. So this is list A. You'll remember that list A documents are those that evidence an indefinite right to live and work in the UK. So you'll see a current or expired British passport is an acceptable document. Note that a cancelled British passport or Irish passport is not an acceptable document. How can you tell the difference? Cancelled passports have their corners clipped, okay? So if it's clipped, it's cancelled. It's not just expired, and it's not acceptable. Another thing to note is at point 4. So you'll see point 4 states that an acceptable document is a current passport endorsed to show that the holder is exempt from immigration control, is allowed to stay in the UK indefinitely, or has no time limit on their stay. So I just want to highlight that this is why people with indefinite leave to remain endorsed in an expired passport need to apply for e-visas, because having indefinite leave to remain in an expired passport is not on this list, okay? It has to be a current passport endorsed with indefinite leave to remain. Next slide, please, Nikki, and then the one after that. This is just to show you the list B group 1 and list B group 2 documents. This list B group 2, again, is the documents that you might be presented with, where you then have to ask the employer checking service for a positive verification notice that would be valid for 6 months. And then you would have to recheck the documents, okay? All list B documents, whether group 1 or group 2, have to be rechecked because they evidence a temporary right to work. Okay, so that's it for manual checks. Let's quickly go over identity service providers. Next slide, please, Nikki. So you can use an identity service provider to check current British and Irish passports. You can't use them to check expired ones. This method is used mostly by large employers with high volumes of new recruits coming through. It basically, as I mentioned earlier, allows for electronic checking of British and Irish passport holders. So that you don't have to ask them to come in or ask them to send in their hard copy documents. Because basically, if you think about it, otherwise, British nationals are at a disadvantage as compared to non-UK nationals in terms of right to work checks, because a lot of non-UK nationals can use the share code system, whereas British nationals are going to have to provide their hard copy passport unless the employer is using an identity service provider. So the identity service provider uses what's called identification document validation technology, or IDVT, to scan the document. They use software to compare the scanned document against samples that they have, templates that they have, and then they provide a document authenticity score. Next slide, please, Nikki. Now, what the IDSP has to be provided with are some details about the individual, a document image, and a photograph or image of the individual. There are processes to allow for the worker to submit some of that, or the employer to submit some of that. And the IDSP is going to confirm the verification of the individual's identity and the date of the check, and provide a record of all elements of the check to the employer. Now, keep in mind that if you're using an identity service provider, first of all, they have to be a certified one, okay? So there are certified providers basically approved by the Home Office for these purposes. Secondly, there is still a level of employer due diligence to be observed, okay? So the employer still has to be satisfied that the IDSP conducted the check in the prescribed manner. You're responsible for obtaining, a record of the check, and you're still responsible for ensuring that the person is who the documentation says they are. So you still actually need to check that the photo and ID details are, including the date of birth, are consistent with the person's appearance. Okay, so it's not just kind of outsourcing all responsibilities for document right to work checking when you're using an identity service provider. Next slide, please, Nikki. Okay, now we are back in the realm of requirements relevant regardless of the method that you're using to check right to work documents, okay? So you have to keep the documentation of having conducted the check on file. So you can do a perfect check, but if you aren't able to show the Home Office the documentation, then it's not going to be worth much. You can keep it in hard copy. or in a digital format, so JPEG or PDF. You have to keep it until the end of the individual's employment and for a further 2 years. Next slide, please. Now, how you keep the documentation will depend somewhat on the method that you used. So for manual checks, what are you supposed to actually copy or scan? Well, if it's a passport, you copy the personal details pages and any pages with UK government endorsements. If it's any other type of document that you're presented with during a manual check, you copy the whole document. If you're keeping hard copy records of manual checks, then you write on the copy the date on which this right to work check was made, and then you insert the date. Then you sign and print your name. Now, listen to me. The Home Office is not going to accept it if you just say, I confirm I checked this document, and then you sign and print your name and you date it, because the Home Office is saying, unless you say the date on which this check was made was such and such a date, that doesn't, then just dating your confirmation is not, they're not going to, does not reflect that you actually checked it on that date, okay? So this is one of the instances, one of the examples of where the Home Office, comes up with its own rules. It's living in its own universe. In any other circumstances, signing, printing your name, and dating your signature would be sufficient, but not in these circumstances. You have to specify, in prose form that the date on which the check was made if you're keeping hard copy records of manual checks. If you're keeping digital records, then you can just keep a separate record of the date of the check. So like a Excel spreadsheet, for example, confirming the date of each worker's check. Next slide, please, Nikki. So that's how you keep evidence if you're doing manual checks. If you've done online checks, so using the share code system that Medea described so beautifully, then you would print the profile page and save it either as a PDF or HTML file. That's going to have the date of the check on it, so you don't need to worry about that. If you've done IDSP, sorry, that's incorrect, it's not ISDP. If you've done IDSP checks, then you will retain that check documentation that's been provided by the IDSP. And again, because you are still responsible for verifying that the person is who they say they are or who the documents say they are, we also recommend a separate record being kept confirming the date on which you check that their identity details are consistent with their appearance. Medea, handing over to you for sponsor compliance.
Okay, let's this section. Perfect. So there are 3 types of duties, sponsor duties, that everyone who is considering or is already sponsoring workers should be very, very wary of. It's compliance duties, reporting duties, and record-keeping duties. So the first type of duties we would consider is compliance duties. Next slide, please. So one of the most important considerations that the sponsor should be giving is to ensure that worker is appropriate for sponsorship. So what it means is that the worker meets the requirements for the role, salary, and there is a genuine need for employing that worker and providing them with sponsorship. That is probably one of the most sort of fundamental compliance duties that everyone should adhere to. The sponsors must ensure that the sponsored worker is only working in a role that is specified on the course. So in case of the Home Office coming and checking or conducting an audit, this will be checked. So somebody that is employed under a certain role cannot perform any other tasks that are not relevant to that role. The sponsors must appropriately assign certificates of sponsorship or course to a worker. There are different types of course. So there is a difference between a defined course and an undefined course. Defined course is for, oh, I have lost my presentation. Sorry, defined course is for workers that are currently based outside the UK, and undefined course is for those who are already in the UK with a permission. When it comes to undefined course, there are further types that a sponsor must be able to distinguish. One of them being is some types of undefined course are immigration skills charge liable and some are not. There are different types of undefined course when it comes to workers switching from student route or changing their immigration category. For instance, if they are currently on a partner visa switching to a work visa, that would be a different type of course. Another consideration is for those who are employed under the global business mobility route, is to ensure that their workers have an appropriate length of service overseas. We will not be going into global mobility business route in too much detail during this webinar, but Samar does provide trainings on those separately. If we could have the next slide, please, Nikki. Do you have, yes. So this compliance duty has been introduced relatively recently, and that sponsors can no longer share fees with the sponsored workers. So by fees, the Home Office includes sponsor license application fee, certificate of sponsorship fee, immigration skills charge, and admin fees. So any premium services or priority service fees, action plan fees, and legal fees cannot be deducted from the sponsored workers' wages, or in fact asked to be refunded to the sponsor in any other way. The immigration skills charge, the restriction on sponsors to recover these costs from the worker, has existed for quite some time, and the restriction has now been widened to include all other fees related to the sponsorship of the worker. So those sponsors who have submitted their sponsor license application after the 31st of December, they are under this duty not to recover these sponsorship costs. And for self-sponsored applicants, it's more of a tip to pay the sponsor license costs from their corporate bank accounts instead of paying them from their own pocket. Next slide, please. Record-keeping duties. So these are separate to the evidence that must be kept to confirm the right to work checks. However, it does sort of align with them quite closely. As a sponsor, you need to have a copy of the worker's current passport on file. If the application was made from overseas, you need to make a note of the entry date of that worker to the UK. So, for instance, some workers would have a stamp in their passport or an entry clearance vignette with a stamp from the border force. Non-visa nationals that are able to use the e-gates will not have entry clearance endorsed in their passport or a stamp. So for those, you must ensure that they entered the UK after they received their skilled worker entry clearance permission, and you can do so by asking to see their tickets or their boarding passes, and then make a note on your systems of their date of entry. You should also have a copy of the worker's view and proof profile or an e-visa. So when you conduct your right to work check, you need to download the PDF of the profile and keep it on file. And you also need to note the worker's national insurance number card, which are no longer being issued, but for some that would still be the case, or any other document that confirms the worker's national insurance number. Next slide, please. The next type of documentation that the sponsors must keep on file is the documentation confirming recruitment of the worker. So just before a sponsor assigns a course to the worker, and this comes as part of the wider make sure the work is appropriate for sponsorship duty. So you need to have a copy of evidence of recruitment of that worker. So if you advertise the role, this would normally be a copy of the job advertisement online. Some sponsors advertise their roles on LinkedIn or platforms like Indeed. So a copy of the original advert, note of start and end dates of that advertisement. And if this was an open role, how many people applied, how many people got shortlisted, and the reasons for selection of that particular worker. So if you have copies of interview notes, list of interview questions, scoring or grading process results, that would also be considered as part of the worker's record keeping. Next slide, please. And of course, for roles that were not advertised, sponsors must still keep evidence of how and why they identified the work as suitable for the role. So if that was somebody who was working previously at the company or somebody who was working at a different branch, some evidence of their performance. If this was a speculative job application, some evidence of that, or if it was milk round, the relevant evidence as well. Next slide, please. Skill level. Yes, this is also part of the is your work appropriate for sponsorship duty. Make sure you have job description for the role saved on the personnel file. If this role required a degree certificate or any qualifications, copies of those as well. Evidence of required experience. This would usually be letters from previous employers confirming the start and dates of the employment. And if the role requires some legal qualification, copies of that accreditation or qualification on file. Next slide, please. Yes, and for the duration of the worker's employment and sponsorship, you need to make sure that you're up to date with the worker's current contact details, their address, their contact numbers, emails. You need to keep record of any absences, payslips, of course, evidence of salary payments, which I guess can also fall under the payslips. And certificate of sponsorship details, these are not strictly required but recommended. So when you assign a course to the worker, if you print the copy of the course and save it on file, that would usually cover this optional record keeping. Next slide, please. Yeah, contract of employment, so it's quite self-explanatory, must have it on file. Next slide, please. And now finally, we're covering reporting duties. When it comes to workers, there are certain events that must be reported to the Home Office within 10 days. So for instance, if a worker doesn't start in their role within 28 days of either the start date of on their course or the date they received their permission, whichever is the latest. If work is absent for 10 consecutive working days, this needs to be reported to the Home Office. Early termination of employment for any reason must be reported. and change of circumstances, if the worker gets promoted to a new role, if there is a change in their core duties or a change in location, work location, or salary reduction. Promotion in terms of raising salary doesn't need to be reported. Next slide, please. And of course, if there are any changes in your organization as a sponsor, those need to be reported within 20 working days. So sale of all or part of the business, merger, acquisition, change of name of the business, and change of premises. And there are a few others that we haven't included in the list, but these are probably the most frequently happening changes. Next slide. So, Samar, I'm passing this over to you to cover.
So the risks of non-compliance, your sponsor license could be revoked. Sponsored workers would have to leave the UK or find a new sponsor within 60 days of the Home Office writing to them to inform them that their leave is being shortened. Your organization might not be able to sponsor workers in the future or might be ineligible to apply for a sponsor license for a certain period of time, depending on the reasons for revocation. Your sponsor license could be suspended. If it's suspended, you're not going to be able to assign certificates of sponsorship, or at least certain types of certificates of sponsorship whilst it's suspended. And if the Home Office finds illegal working as a result of failure to fulfill sponsor duties, such as reporting changes in roles or applying for, if you haven't applied for if you haven't supported a new sponsored worker visa for an individual, if their role changes significantly, then criminal and civil penalties for illegal working might apply. Now, the requirements around termination, the considerations around termination of a sponsored worker are quite nuanced. I do recommend getting advice in those situations if you have questions. Next slide, please, Nikki. Let's talk a bit about compliance checks. So compliance checks these days can take one of three forms. Either you could be visited by the Home Office. They could conduct a digital compliance inspection. So that's where they might interview you by video conference. Or they might review their own records and then also request evidence and information from you. That's what immigration practitioners tend to call a compliance check by correspondence. They're asking for screenshots and other documentation of your compliance. Let's take a bit of a closer look at compliance checks. Next slide, please, Nikki. So what might trigger a compliance check? Home Office intelligence, a poor record of compliance with other government bodies. So there's more and more data sharing between government departments, and HMRC is a department that the Home Office shares a lot of data with. So non-compliance with HMRC requirements could trigger a check. Sponsoring a certain number of migrants might also trigger a check. So if you, they don't define the numbers, but if you very quickly go from 0 to hundreds of sponsored migrants, you're likely to be checked by the Home Office for compliance. So in terms of visits, the Home Office might turn up unannounced. Now, it is unlikely that they will not notify you that they intend to visit for their own safety as much as anything. But what does happen a lot is actually they send you an email saying they're going to come to visit and you don't receive it. So it goes into a spam mailbox, or you haven't updated the personnel on your license and that person's left. And so, effectively, they do turn up unannounced, not because they didn't tell you, but because you didn't get the notification. That actually happens quite a bit. So it is important to keep the details up to date and check those spam boxes because obviously you're on the back foot if they just turn up. Now, it is possible in those situations to ask them to reschedule, but it's not a great look for you, so try to avoid it. If you are informed of a check, if you're notified they're coming to visit or you're informed of any type of compliance check, please do seek advice. You know, we're definitely ready to help, but you know, this isn't a plug. You can go elsewhere, but get some advice because time is of the essence, and it's really important to address the Home Office's concerns in a very robust way if you want to retain your license. We do have an excellent track record in that, and we're happy to help if you do get notified of a check. Okay, let's talk about what happens during these checks. Next slide, please, Nikki. So one thing that's going to happen is an interview. Nikki, if I could have the next slide. The interviews would happen during an in-person check or during a digital check. As I mentioned, they might conduct an interview by video conference. Now, they will interview key personnel and at least 3 sponsored migrants, if you have 3 or more. And they're going to assess for the key personnel, like the authorizing officer, they're going to assess your knowledge of and compliance with sponsor duties. And they're going to assess the credibility and genuineness of the roles. So when they're interviewing the workers, they're going to compare how the worker describes their role against the description that's on their certificate of sponsorship and assess the genuineness of the role. So if you are subject to an interview by the Home Office, please ensure that you check the interview record before you sign it and request a copy of the interview record. Nikki, the slides aren't changing for us. We're now on a slide called, so this is the interview slide. If we could go one more, please. Right, so evidence and information that they're going to request when they're checking. So they're going to request information and evidence of your HR systems. So basically they want to see that you have systems in place to be able to fulfill sponsor duties, okay? So they're going to ask for screenshots of your Word and Excel documents. They don't want to see only that you have, you know, the documents, but that you're using them. So maybe you have a spreadsheet of expiry dates, but if it's empty, then it doesn't count for much, right? They want to see that the systems are in use. Now, they're also going to be looking at specifically how you monitor immigration status. So right to work checking processes. That's the most important process for a sponsor to have in place. Recording expiry dates and keeping records on file, including workers' contact details. Now, each sponsored workers' personnel file should reflect that record-keeping duties have been met in relation to that person. So again, Medea beautifully described, you know, what you need on file in the record-keeping duties section of this presentation. Those are the documents that the Home Office is going to be looking for in relation to individual workers. Next slide, please, Nikki. So the Home Office is really hot on tracking and monitoring of sponsored workers. They want to know how you know that somebody is working on any given day, okay? And in hybrid working, remote working is allowed, though sometimes it needs to be justified depending on the circumstances. But they want to know how you know that the person is working in those circumstances and generally. So maybe there's a daily attendance sheet. You might use attendance software. They might want to see spreadsheets of absences. You might have a daily Scrum meeting, and so then, you know, in the tech sector anyway, and then a workers manager would know if they're not if they're absent on the day because they're not present at the morning's daily Scrum meeting. And you have to think about how you're tracking people at different job locations. Is permitted to have a sponsored worker at a client site under certain circumstances? How do you know that they're working on any given day? Okay, so something to consider. Next slide, please, Nikki. So after the compliance check, the Home Office is going to write with a decision. They might downgrade, suspend, or revoke your license. We would then challenge that, suspension or revocation and argue for retention. We would also request the report of the check from the Home Office. So next slide, please, Nikki. What I'd like you to think about is compliance at your organization. What do you have in place? To what extent do those systems depend on you specifically? What do you do to ensure the duties are met? And basically, the way to think about it is, if the Home Office showed up, how would you demonstrate to them that you're satisfying that you're fulfilling sponsor duties, that you're satisfying your responsibilities as a sponsor? Again, we can help with this if you're not sure that your systems are robust, and you would be able to demonstrate that to the Home Office. All right, Medea, over to you for tips and updates.
Thank you. Next slide, please, Nikki. So key personnel, we didn't really go into much details about key personnel in this webinar, but something to note for new sponsors. The Home Office brought back the requirement that at least one level 1 user on a sponsor license must be both director, employee, or partner of the company and a settled worker. So this applies to applications made on or after 31st December 2024. So, for instance, representatives can no longer be appointed as level 1 users at the application stage. And if you do want your representative to act as level 1 users, you'd have to wait until your license is granted and then make a separate request. In addition, representatives, they can be still acting as key contacts at the application stage, but no longer level users. Next slide, please. Yes, so these are our tips that we have worked on in our recent practice. So cost allocation applications, this imply defined cost and request for increase of undefined cost allocations. When you submit this request on your sponsorship management system or SMS, you must ensure that you include as much information as possible, because the Home Office has been quite meticulously processing these requests as of late. And to avoid any delays, make sure that you have the role details, the SOC code, salary requirements, hours. If the job is on a client contract or not, you need to make sure that you add that information. And for those sponsoring care workers or senior care workers, make sure you confirm that your organization is registered with the Care Quality Commission or CQC, or if it's not registered, provide a reason why not, and include work locations where your care workers would be employed. The Home Office has on occasion returned to sponsors asking for more evidence. So in that case, we receive requests for reasons for recruitment. We are also asked to provide company hierarchy or and description of the sponsor's business, copies of client contracts, payroll details, business bank statements. So the Home Office requests for additional information tend to be quite extensive. So our tip is for sponsors to be prepared and have this information on hand in case they receive such a request. Next slide, please.
Okay, so I'm conscious that it's 12 o'clock now. Sorry, we're running a bit over. I'll just rattle through these next few slides. So one tip in terms of new entrants, if you come across somebody you really want to hire, but you're not able to satisfy salary requirements, one thing to consider is whether there is a recognized professional qualification or chartered status that they could pursue that's relevant for the job for which they're being sponsored. If so, then they can access the lower salary levels that are afforded to people categorized as new entrants. So that's just a small tip for you. Next slide, please. Update on self-sponsorship, or what we call the sponsorpreneur route, is that if you are setting up a company and that company will sponsor you as a skilled worker, the Home Office now has an informal, unpublished policy of requiring these companies to demonstrate revenue generation or the ability to generate revenue imminently, and asking for evidence. So contracts and invoices. Sponsor license applications are being refused on the basis of lack of genuine vacancies or no trading presence, where people are attempting to pursue this self-sponsorship strategy. Consider the UK expansion worker route as an alternative. You must not already have been trading in the UK to qualify to be eligible, although some market research might be allowed. So we're happy to advise on that if you're seeking to expand to the UK. Next slide, please. The Home Office is expanding employment law requirements for which sponsors are responsible. And so you do have to tick all the employment law boxes if you're a sponsor. That includes national minimum wage, working time regulations, holiday and sickness pay, health and safety requirements, and trade unions and worker rights. Next slide, please. So that's all we have for you today. I'm sorry we ran over by a couple of minutes. We'll stick around for a short while in case anybody wants to put some questions in the Q&A function. Otherwise, you have our email details there. Please do get in touch. I would say that in compliance matters, time is of the essence. So if you're notified of a fine or a compliance check, a sponsor compliance check, please get in touch with us as soon as possible. As I said, we have a very good track record, but we do need time to prepare the most robust responses to the Home Office. So I hope that was helpful. We will circulate a recording of this webinar. We're not going to circulate slides. We generally don't. But hope to see you again soon, and I hope that that was helpful to you. Thank you so much for joining us. We don't seem to have any questions.
No. Yeah.
I think we'll just sign off.
Thank you, everyone. Bye.
Bye, thanks.